Call the case. Just a couple of things. I want to thank the lawyers and their clients for participating in this oral argument by this process. The Zoom oral arguments have allowed the court to continue to do the work of the people of the state of Tennessee. But we couldn't do it without the lawyers' help on this process. If we should have any technological problems, we'll just take a pause and our clerk's office, our clerk staff, and our AOC IT people will address it and take care of it. And I have no idea what they do, but they'll address it and take care of it. So, but don't worry about it if we do that. Call the case, please.
Reginald M. Younger versus Kibreab, Okbahhanes.
We'll hear from the appellant.
Good afternoon, Your Honors. Michael Petherick of the Chattanooga Bar here for the defendant and appellant in this matter. At this time, I'd like to request that the court allow me to reserve 5 minutes of my time for rebuttal.
That'll be fine.
Thank you. Now, this appeal raises an issue of first impression under Tennessee law, specifically the construction of Tennessee Code Annotated Section 28-3-104A2. That statutory provision was enacted in 2015. It has not been interpreted by any Tennessee appellate courts to date. And in pertinent part, it extends the 1-year statute of limitations for personal injury lawsuits to 2 years in cases in which a defendant's allegedly tortious conduct also results in criminal charges in a criminal prosecution brought against the defendant. Now, the trial court in this case denied my client's motion for summary judgment and specifically held that based on the undisputed material facts in the case, the issuance of a traffic ticket to my client and his subsequent payment of a fine in lieu of disputing it and appearing constituted criminal charges in a criminal prosecution. Respectfully, Your Honors, we contend that the trial court erred in denying my client's motion for summary judgment based on the undisputed material facts, and that its construction of the terms criminal charges and criminal prosecution was erroneous because it contradicts the ordinary and plain meaning of those words, the meaning those words have under other Tennessee law, and perhaps most importantly, the intent of the legislature, as can be seen in the legislative history of the statutory provision. Now, our first argument, Your Honors, is pretty straightforward. The meaning the trial court ascribed to the terms criminal charges and criminal prosecution contradicts the plain, ordinary, and common sense meaning of those words. Normal people don't ordinarily throw around the term criminal charges and criminal prosecution when they receive a traffic ticket. If I were to get a traffic ticket on my way home today, I certainly wouldn't be telling everybody subsequently I was criminally charged and criminally prosecuted when the officer gave me this ticket.
Ordinarily, charge is it the ticket we're concerned with or the charge that is made in the ticket?
It's not the charge that is made in the ticket or the allegation of criminal activity. We don't dispute that the allegation that my client violated the failure to use due care, it's a criminal offense. So it's not that, it's whether the ticket is a charging instrument. And that's because normally...
So what are you saying then? That in order for him to be charged with a criminal offense under this statute, that he has to be hauled off to jail instead of ticketed, or what?
No, Your Honor. What we're contending right now is just that traffic tickets constituting criminal charges doesn't go along with the common and ordinary understanding of the words criminal charges and criminal prosecution. The fact is that normally when people refer to criminal charges, they refer to accusations of criminal activity that have been brought to a certain level of formality, such as through a charging instrument or through, for instance, a grand jury. And that's not what we have with a traffic ticket. And there are good reasons why that meaning, the more formal meaning of criminal charges and criminal prosecution, should apply to this statute. It makes sense.
What definition do you have that has been promulgated by the legislature regarding a criminal charge that would exclude a traffic ticket being issued?
Well, Your Honor, there isn't specifically necessarily a definition of charge that we're relying upon, but rather the understanding of how the criminal process works. And the fact is that criminal prosecution under Tennessee law, and this is to my second argument, it cannot be commenced unless there is a legally adequate charging instrument. Logically, a criminal charge is the beginning of a criminal prosecution. Under Tennessee law, criminal prosecution can only be commenced if there is a charging instrument that adequately describes the facts and circumstances at play. And the fact is that there's a lot of Tennessee law out there saying, for instance, and we cited these cases in our brief, there were several cases out there saying that for instance, an affidavit of complaint, which is even more formal than a citation, is not a charging instrument and does not commence a criminal prosecution. But perhaps the more important case, and one that we pointed out in our notice of supplemental authority that we filed, is State versus McLeod. And in that case, the Court of Criminal Appeals specifically stated that a citation issued by an officer in lieu of a custodial arrest is not a formal accusation of criminal activity, and that it therefore cannot commence a criminal prosecution. And, even besides the case law, the Tennessee legislature has specifically defined the commencement of a criminal prosecution, at least for purposes of the criminal statute of limitations, which I personally find very compelling, given that we're dealing with another statute of limitations. And in that statute—
Counsel, let me enter here. Let's say your client didn't just send the fine in, decided I'm going to contest it, shows up to contest it, what happens?
Well, Your Honor, obviously, and I'd like to begin by pointing out that that's not the circumstance in this case. But
I understand.
Yeah, as a theoretical matter, if that were the case, he would be appearing in court to dispute it. And the fact is that the legislature and Tennessee courts have identified that a defendant's appearance to defend the matter marks the commencement of a criminal prosecution. Does that answer your question?
So if he shows up, it's a criminal prosecution. You'd say that fits under the statute.
Yes. And the fact is,
but if he doesn't show up, there's no commencement of it.
No, Your Honor. It's because it's sort of forestalling that process. I guess in a way, it's more analogous to like a parking ticket or something like that, where it's a governmental body that's penalizing an individual. However, it's not rising to the formality of a criminal prosecution. Does that answer your question?
I don't know. I'm troubled a little bit, but I'm looking at subsection B. It says the conduct, transaction, or occurrence that gives rise to the cause of action for civil damage is the subject of a criminal prosecution commenced within 1 year by a law enforcement officer.
Yes.
And you're saying if the citizen shows up to contest it, then it's commenced. But that if the citizen just says, fine, I'll pay the fine, that it's never commenced by the law enforcement officer.
No, Your Honor, because, at that point, when, they arrive to dispute it, that's the appearance, as I said, and that's what's identified under the statute that I was referencing, that the Tennessee legislature, where they've defined commencement of a criminal prosecution. But the fact is that if the payment of a fine is the situation instead, as here, it's payment of a fine in lieu of appearing. And therefore, it forestalls the process of the criminal prosecution being commenced.
So it's never
So-
commenced, even though he pays a fine.
No. That's
Now, what's he paying the fine on if the criminal charge is never commenced?
well, in that sort of situation, Your Honor, it's more of analogous to, as I was pointing out, a fine for some other sort of civil penalty. And also, I think Your Honors will find that the legislature didn't really intend for the statute to apply to more informal sorts of situations like we have here. In the earlier drafts of the legislation.
Before you get to that.
Yes.
What about the statute is ambiguous that makes us need to look to the legislative history?
Well, Your Honor, we contend that you don't even necessarily have to reach to the legislative history. The fact is that we contend that the plain and ordinary meaning of the terms criminal charges supports our position. However, the fact is that we're here with two radically different interpretations of the statute being advanced. So to the extent Your Honors feel that there is an ambiguity based on that fact alone, we contend that the legislative history would certainly come into play. So, which, as we said, supports our position, a more formal criminal prosecution and charging process. But I'll yield since my time is out.
You have your time for rebuttal. Thank you.
Thank you.
We'll hear from the appellee.
Your Honor, I'm John Chandler of the Chattanooga Bar. I represent the appellee or plaintiff, Reginald Younger. Your Honor, I'm not going to waste any time addressing the issue of whether this is a criminal charge because the defense appellant has basically conceded that in their reply brief. I'm going to go directly to the issue of whether or not a prosecution was commenced. And I've got three arguments on that. One is the language of the statute that we're arguing about itself. As Judge Sweeney, as you pointed out, in that statute, it says, and I'm quoting from TCA 28.3.104, little a, little 2, capital B. The conduct, transaction, or occurrence that gives rises to the cause of action is the subject of a prosecution commenced within 1 year by a law enforcement officer. I believe that is critical language, as I think you recognize, because under TCA 40-2-104, the statute that talks about prosecution commencement, it lists 7 different ways that a prosecution can be commenced, including finding an indictment or presentment, issuing a warrant, and so forth and so on, none of which can be accomplished by a law enforcement officer. So therefore, I believe that this legislation was not intended to be read technically to make sure the commencement was constitutionally proper or procedurally proper. If a law enforcement officer provides the driver with a traffic citation, as occurred in this case, takes that to the General Sessions Court, swears to it before the court clerk or a magistrate, that commences a criminal prosecution. And as you pointed out, in this particular case, Mr. Okbahhanes paid the ticket online, which he had the right to do, rather than make an appearance or contest the charge. And by doing so, he basically ended the prosecution. How could there be a prosecution and payment of a fine if there's no commencement?
Mr. Chandler, your argument about the statutory language of 40-2-104, that could cut against you as well, could it not? Because it does list the specific ways in which a criminal prosecution is commenced. And you conceded that it is not part of that statute. The issuance of a citation by a law enforcement officer is not encompassed within that statute, correct?
Absolutely, Your Honor, and I concede that. I concede that if, but it didn't happen, Mr. O'Baines wanted to argue about this, contest this. He has a time limit to do so, as was set forth in the Morgan Moran case. He didn't do so. He waived any and all constitutional and procedural deficiencies, if there were any. And he might not have been prosecuted technically under that statute, under the 7 ways that statute allows. But once again, the legislature, in drafting the statute we're here about, the statute of limitations we're here about, specifically listed law enforcement officers as commencing a prosecution. So I think if you look at the language of the statute itself we're dealing with, that's the only, all the law enforcement officer can do is issue a citation. He cannot issue a warrant. He cannot obviously impanel a grand jury. So I would suggest that they did not intend the statute to be restricted to situations where one of the 7 ways of prosecution can be commenced by the by 104 list.
All right, I want to ask you about your response to the McLeod case, which they provided a supplemental authority. And in that case, the Court of Criminal Appeals said that just as a warrantless custodial arrest does not alone commence a prosecution, a citation issued in lieu of an arrest is not the result of independent probable cause and therefore does not mark the beginning of a prosecution.
Once again, Your Honor, if Mr. O'Baines wanted to challenge this, make a constitutional or procedural challenge, he would have prevailed if he did so timely, as was discussed in the Morgan Moran case. But he didn't do so. It's too late for him to raise that issue now and say, I wasn't properly prosecuted or constitutionally prosecuted. He may have had a valid argument, but it has been waived. It's too late for him now to bring up that issue or to raise that issue. And we've got the Farrell case that I think is, I cited in my brief, that is later than the McLeod case. And in that case, it involved the issuance of a seatbelt citation. He actually challenged it, and the Court of Criminal Appeals in that case, which is a I want to say 2017 case. I believe that's correct. 2017 case said that for certain offenses, including a violation of seatbelt law, the statute requires the issuance of a citation in lieu of arrest. And I think that also applies in this situation as well, with the charge against Mr. O'Baines by citation. So I guess I've tried to summarize. I think I have 3 responses. The language of the statute we're dealing with, TCA 28-3-104A, itself lists commencement of a prosecution by a law enforcement officer. As we discussed under TCA 40-104, a law enforcement officer cannot commence it under that statute. But the legislature said a law enforcement officer could commence it for purposes of this statute of limitation, Your Honor. And that's exactly what we're dealing with.
So then does the statute of limitations only apply then when the criminal prosecution is commenced by a law enforcement officer, which we know only happens with the issuance of citation? So I think if I take your argument to its logical extreme, this statute of limitations only applies to traffic tickets and doesn't apply to cases where you have presentments and indictments, because those things aren't listed in the statute.
Well, they are, Your Honor. Referring to the 28-3-104, once again, subsection A to B, it lists commenced within 1 year by a law enforcement officer. That's the first. The second is a district attorney general. The second, or the third, a grand jury.
Okay.
So it's not limited to traffic tickets, but it is expanded to include traffic tickets because law enforcement officers can't they're not a grand jury. They're obviously not the district attorney general, but they have the power to expand this statute of limitations from 1 year to 2 years by issuing a citation and doing it properly. And once again, that's my first argument, the language of the statute itself. The second argument is that Mr. Okbahhanes, if he had any constitutional challenges or procedural challenges, he waived them. He paid the fine. Those are over. The time period for him to appeal is over, as the Moran court stated. He can't come back now a year or two later and say, well, I really didn't mean to plead guilty to that offense. It's too late for him to do so. And then the third argument, Your Honor, I haven't addressed, Your Honors, is kind of a practical argument. I've never handled a criminal case in the 45 years I've been practicing law. I know nothing about criminal law. Judge Pemberton used to be a general sessions prosecutor. He held this was clear and unambiguous, no doubt about it, and denied the motion for summary judgment. Every criminal lawyer I talked to told me, hey, when the police officer gives them a citation, takes it down and swears it in front of the magistrate or the court clerk, the prosecution is commenced. Well, guess what? If the argument of the defendant is accepted, they're all wrong. I don't think civil lawyers are going to be able to figure this out. I've spent hours learning about criminal procedure and all the ins and outs, the constitutional and procedural requirements. The legislature wanted to get...
Should we transfer it over to our friends in the Court of Criminal Appeals?
I would suggest that you might want to consult with them. I mean, I'm being honest about it. This is something that is really beyond my ability to deal with without spending a significant amount of time learning about criminal procedure. But the point is this statute deals with the extension of the statute of limitations for filing civil lawsuits. It's going to be used by Tennessee attorneys who handle civil lawsuits. And many of those attorneys, like myself, will have absolutely no knowledge whatsoever about the commencement of a prosecution. And as you can tell, this can be a very detailed, very difficult area to even get a grip around. And the point is that a civil lawyer, and let's take the case that they're relying on, that they provided to the court recently, the McLeod case. You have a wreck. There's a DUI charge asserted against one of the drivers. The other driver goes and hires a lawyer. He says, look, let's see what happens with the DUI case. Let's see if he's convicted, and let's see how that goes. So let's don't file suit immediately. And by the way, we've got this statute, TCA 28-3104, which allows us to wait over a year to file suit to see what happens in the criminal case. They wait over a year, the man's convicted, and then I don't know how many years it was after the conviction in the McLeod case. I don't have that detail in front of me, but it's 2 or 3 years after the conviction when it ends up at the Court of Appeals and Criminal Appeals, and they throw it out. That's a malpractice trap. I don't think the legislature intended to create that kind of trap for plaintiffs' lawyers in Tennessee. If you reasonably rely on the conviction, I mean, in that case, in the McLeod case, he was not only charged, he was prosecuted, and you rely on that, you wait for the 1 year to run, you file it after all that process is completed, as the legislature discussed in the brief legislative history that's available. And then guess what? 2 years later, that criminal charge, or a year or two later, that criminal charge is thrown out because it wasn't constitutionally and procedurally perfect. That is not what the legislature intended, in my opinion, and I don't think there's a good argument to the contrary on that.
Counsel, let me ask you one. I'm interested whether or not it's a PCA 5510-207D, and I want to know your opinion when I ask your opposing counsel when we get this back up, if it has any impact here, where it's talking about, the whole section, or the whole 207 is talking about, punishable as a misdemeanor if you're arrested for this or that. But Section D says, whenever a traffic citation has been prepared, accepted, and the original citation delivered to the court as provided herein, the original citation delivered to the court shall constitute a complaint to which the person cited must answer, and the officer issuing the citation shall not be required to file any other affidavit of complaint with the court.
Your Honor, I certainly think that, of course, helps my argument. And in fact, I believe there's a case that I cited that addresses that specifically. And I think it's the seatbelt case, the Farrell case, that I cited in my brief, State versus Farrell, 2017 Court of Criminal Appeals case. And it quotes that statute specifically as part of its holding that even though the man wasn't arrested, the prosecution was commenced and the conviction was upheld. And that's even a later case than the new case, the McLeod case, which I think is a 2009 case relied on by the defendant. And I don't really have much else to say, Your Honors, unless you have questions for me.
I hear no more questions, but thank you. We'll hear from the appellant rebuttal.
Thank you, Your Honor. As an initial matter, Mr. Chandler said that we conceded that there was a criminal charge, and that's not true. To clarify, we're just not disputing that the offense at issue, which is failure to use due care, is in the criminal code. Whether there is a criminal charge in this case depends on whether there was actually a charging instrument such that the criminal prosecution was commenced. Now, another point.
What you said in your reply brief was that the client does not dispute that a violation of TCA there may constitute a criminal offense.
Yes, Your Honor, that's fair enough. But we do not concede that there was a criminal charge, and that's where the distinguishing factor is. Another point.
I want you to address though my question I gave to your opposing counsel about 207 subpart D. What do you think? I mean, how does that impact this, or does it?
Well, Your Honor, what I think it means is that when a citation is issued in accordance with that statute, it means that the officer does not need to subsequently file an affidavit of complaint. It specifically references affidavit of complaint. But the fact is, as in several of the cases that we pointed out, a prosecution does not commence upon the filing of an affidavit of complaint. It's not constitutionally adequate to commence the prosecution. Now, something may occur later, and I'd like to point out in State versus McLeod, which we've obviously addressed, the Court of Criminal Appeals kind of went through, differing levels of formality in the charging instruments. There was a citation issued against the defendant. There was an affidavit of complaint that was filed. He was eventually bound over by the grand jury. And also there was an indictment that was issued, and the indictment was issued after the 1-year period. The Court of Criminal Appeals said, well, when was this commenced? The fact is that it wasn't commenced with the citation. It wasn't commenced with the affidavit of complaint. It was commenced within the 1-year period with the binding over the offender. So the fact is,
counsel, but I mean, I'm having trouble getting through this. What was the purpose of the General Assembly, not for the criminal law, just simply as to whether or not to extend the statute of limitations, or saying criminal prosecution commenced with 1 year by a law enforcement officer?
Well, Your Honor, I guess
how can the law enforcement officer commence it?
Well, Your Honor, that's a good question. I mean, depending on how you look at it, they can make they make the initial accusation of criminal activity. Personally, if I were drafting the statute, I would have drafted it differently. I think it's kind of ambiguous, but the fact is that the officer can file an affidavit of complaint, and then subsequently a warrant could be issued, an indictment could be issued, or the person could be bound over. So I think that that's kind of an explanation as to that language.
I don't understand. If you go to the indictment, grand jury, district attorney, they're involved. I mean, what purpose does subpart I, number one, little one, say? Can be committed within 1 year by a law enforcement officer.
Yes. Well, Your Honor, the fact is that I don't, obviously there's Tennessee law governing whether, a criminal prosecution is commenced. And I don't necessarily.
I'm not talking about the criminal law. I'm talking about what did the General Assembly, we're supposed to treat it as they know what they're doing, and every word has meaning and is to be given effect. What effect should we give to subsection I?
Well, Your Honor, I think that the effect that it has to be given, obviously there's a presumption that the legislature intended their statute to be compliant with other provisions of Tennessee law, and that it needs to be construed in accordance with that. I would argue that in effecting that intent, that the legislature did not intend for constitutionally inadequate allegations of criminal activity to all of a sudden constitute the commencement of a criminal prosecution.
But only for purpose of that statute. I mean, all they were doing was, here's a situation, we'll extend the statute for an extra year. I mean, this statute doesn't do anything to change any criminal statute, does it?
No, Your Honor, I don't think it does. It's purely for the civil statute of limitations. But the fact is that once again, this court's construction of the statute is governed by several principles, including that it's not going to be construed so as to go against other provisions. And with that, Your Honor, if I've answered your question, which I hope I have, I see I'm out of time.
That's fine. You can wrap it up. You can take some time to wrap it up, because I took most of your time asking you stuff here. So if you have a couple of sentences you want to say to wrap it up, feel free to do so.
Okay. Yes, Your Honor. All I'd like to say in summary is that the trial court's construction, obviously we've already argued plain meaning, we've argued legislative intent. In other Tennessee law, we contend that the trial court's construction of the statute contradicts the plain meaning, the bodies of law that have to be examined when construing the statute, as well as common sense, we would argue. And for that reason, Your Honor, we contend that the trial court's order should be reversed.
Thank you. Thanks to counsel, excuse me, for both sides, both for your briefs and your oral argument. It is an interesting question. It is first impression. That's why we granted the Rule 10. So if you would please adjourn court till our next regularly scheduled docket.
This honorable court is now adjourned.